ICC prosecutor Luis Moreno Ocampo's bid to have events in Kisumu and Kibera during the post-election violence reinstated as evidence against 3 of the 6 post-election violence suspects fell flat on its face after Judge Ekaterina Tredafilova, acting on behalf of the pre-trial chamber, dismissed the appeal application. The judge found that the evidence presented by the prosecutor did not provide reasonable grounds to believe that the events which took place in Kisumu and Kibera could be attributed to Muthaura, Kenyatta and Ali under any mode of liability embodied in the Rome Statute. Ocampo's appeal bid took a further beating as the judge also rejected his application to have the pre-trial chamber reinstate his classification of forced circumcision as a sex crime. The judge ruled that Ocampo failed to convince the court that its classification of forced circumcision under other crimes was prejudicial to his case and justice. The ruling came as the court received the application filed by 2 British lawyers on behalf of the government of Kenya, challenging the ICC's jurisdiction on the Ocampo 6 cases. In the application, the lawyers asked that the court grants the Kenyan government an opportunity to address the court on the 7th and 8th of April, the date set for the Ocampo 6 appearance at The Hague. Kenya is basing its admissibility challenge on the provisions of the new constitution and ongoing reforms. The application indicates that Kenyan local courts will now be capable of trying crimes from the post-election violence, including the ICC cases, without the need to establish a special tribunal, which previously proved difficult. The application proposes a timetable that illustrates the government's plan in dealing with the cases. In the timetable, the government should, by the end of July 2011, give a report on investigations under the new Director of Public Prosecutions, showing how the investigations go to the highest levels of responsibility. 2 other reports will be submitted to the ICC in August and September. Divisions, however, emerging within the Grand Coalition government, with cabinet ministers allied to Prime Minister Raila Odinga disowning the application.
We have not sat at any other committee or in the cabinet and decided that now we appoint certain lawyers to raise the technical point of inadmissibility. We have not.
Reports indicate that the pro-Raila faction of ODM is considering writing to the ICC, seeking that the pre-trial chamber dismiss the application as it does not represent what they are calling an official government position. Newton Ndebu, KTN Prime.